Circuit, the Ninth Circuit experienced a rate of summary reversal more than 6 times higher than the next busiest circuit. Now, to be fair, that was looking at from 1985 to 1997, but he went on, as Ninth Circuit Judge O'Scanlan, I'm sure I'm mispronouncing his name, noted in a 2013 article, quote, approximately 1 in 10 Ninth Circuit cases reviewed by the Supreme Court results in a summary reversal, end quote, and another half are reversed unanimously in a non-summary disposition by otherwise an ideological divided court. Moreover, according to Mr. Eastman's testimony, the combined reversal rate of the 5th and the 11th Circuit is much lower than it was before the 2 circuits were split from the old 5th. And so the question goes, was Chief Judge Posner wrong in his conclusion that the quality of judicial output declines as the number of judges on an appellate court expands? And if he is wrong, why is he wrong? I mean, he's citing some fairly strong evidence over a 12-year period.
One second. Well, I guess I'll start, if you don't mind. It's of course, when I hear those statistics, you recall that he's talking about a period before I even joined the court 20 years ago. So if you look at different periods of time on summary reversals, you actually get much different data. And I have looked at that because the subject seems to come up a fair amount because they want to use that as a statistic. But I think the more important question is does size affect quality of deliberation? And in the Ninth Circuit, I would say absolutely not. And I think that our deliberations now are even better than when I joined the court because of technology. We are exchanging views every single day in rapid form. And we have different judges who take different interests. Some are interested in intellectual property. Some are very concerned about the consistency of even our unpublished decisions. Some are concerned about bankruptcy law. And some are concerned about environmental law. And all of these judges bring different perspective to the court. And we have free and robust exchanges every day in terms of the kind of collegiality that Professor Eastman was talking about. So I think I don't mean to.
No, go ahead. Go ahead.
But my colleagues may have a different.
I mean, he looked at very statistical information and drew the conclusion that there is a direct relationship. I can tell Professor Fitzpatrick wants to jump in here. Go ahead.
Judge Posner is simply one of the most respected judges in the history of our court system. Perhaps the only federal judge that is smarter than Judge Posner is Judge Kaczynski. And I think that he deserves great weight when he runs the numbers and comes to the views that he does. And again, it's consistent with everyone else that has looked at the data. Again, the study by Dr. Kevin Scott for the Federal Judicial Center, it all says the same thing, which is size matters.
And representing I think the number is more than 65 million people. I'm just not buying that it's faster and that support services. I mean, our population has grown over the years by tens of millions of people. And there does come a time when I think you need to split. And I got to tell you, there is a great deal of frustration with the Ninth Circuit. There are people that are absolutely fed up with some of these things. As a member of Congress, I got to tell you, the rulings that we've had coming out against President Trump to protect our borders and secure this nation, while none of you on this panel made that decision, is infuriating to us to look to the Ninth Circuit to see people say, well, there's 70 people here that we got to protect and 80 people here. What about protecting the United States of America? And it's the Ninth Circuit that is causing these problems and taking away the duties that the Judiciary Committee, the Congress, has given to the President of the United States to protect our borders. There are people that are outraged about this. And those are specific cases with specific judges. But I got to tell you, according to some others that I hear on this panel saying, where's the outrage? There are a lot of us that are outraged. The president was duly given by Congress the authority to protect our borders. And for these injunctions to come in place and prevent the president from doing his job is absolutely, totally wrong. I do think, Mr. Chairman, this is the right way to do this and to look at it. I do think that certainly Chief Justice Posner and some of the panelists here are on the right track. I think being able to deal with things in block, too, should also be given some heavy weight, and that is clearly not happening in the Ninth Circuit. I yield back.
Mr. Chairman,
I think
since I've been compared to Judge Posner, can I venture an answer? It won't take very long.
Your Honor, I might someday be in your court. How could I deny you?
Good answer. You know, a model is, I have a great deal of respect for Judge Posner, but Dick and I disagree all the time on all sorts of things. And the model is only as good as the inputs you put into it. If you leave out important considerations, the model is going to give you the wrong answer. The period in question that Judge Posner looked at overlooked the makeup of the two courts. And the reality is that in late 1970s, the Ninth Circuit moved from 13 judges to 23 judges, and President Carter was able to appoint 11 or 12 judges to the Ninth Circuit, some of the most liberal judges the world has ever seen. Good friends of mine, with whom I disagree a great deal. And they had a tremendous influence in the jurisprudence of the court at that time. At the same time, the Supreme Court was very much going in the other direction. And so much of the disparity that Professor Fitzpatrick and Judge Posner refer to, you can only attribute to size if you think that judges are blank spheres. If you take into account who the judges were that populated the two courts, that explains it. It's not a question of size. Problem with Dick Posner's analysis, is he looked at the wrong thing. He looked at size, whereas really it was the composition of the panels that made the difference. Now, the fact that we're reversed by the Supreme Court doesn't mean we're wrong. It may mean the Supreme Court was wrong, at least in the view of my colleagues. But I think that's what was going on there.
Well, I thank you, and I'm going to be forced to move on if you don't mind. We now recognize the gentleman from California for his round of questioning, and I trust that we'll continue this lively back and forth of, you know, size matters, it doesn't matter, ideology matters, it doesn't matter. But I would admonish all of us that we are trying to figure out whether to split the court for reasons that should not be ideological by definition. Thank you.
Thank you, Mr. Chairman. I clerked on the Ninth Circuit Court of Appeals for the late Judge Thomas Tang. The Ninth Circuit had awesome judges then. It has awesome judges now. And what I want to ask, and first of all, thank you, Judge Kaczynski, for being here. My friend, Beverly Hills School Board member Lisa Korvatoff says very kind things about you. I want to ask you, as an appellate court, you have to take all cases, isn't that correct? Unlike Supreme Court, you can't decide to pick and choose.
Of course.
Right. And it is no secret that states like California are just more progressive than, for example, a state like Kentucky. And isn't it possible that because you have to take all cases, you're just going to get a higher proportion of cases that push the envelope, that challenge the status quo, that are more progressive? And as a result, some of the statistics you're seeing are because of the cases that are brought before you. Is that correct?
That's certainly right. And of course, that would be exacerbated if California were isolated. One of the ideas of regional circuits is that you have no single state dominates a circuit. That if you have a large state, you will have surrounding states that will provide other perspective, the rural perspective, the mountain perspective, the environmental perspective. And isolating California would only exacerbate the problem of which you speak.
Thank you, because I see many of the statistics that my colleagues on the other side bring up, and they're statistics without any meaning. I don't think the relevance is what percent does any particular circuit get reversed. I think the relevance is the quality of the opinions coming out of this circuit, and are they doing some groundbreaking opinions? So, for example, in 2014, when the Ninth Circuit went out and said, you know, bloggers have the same free speech protections as traditional press, that was a pretty awesome and amazing opinion. And that's the kind of things that we see out of the Ninth Circuit. And so I think the real statistic is, what are the quality of opinions coming out? Are the judges putting down their rationales? Are they explaining to the American people what they are doing? And for the record, I note that multiple judges have imposed a block on Donald Trump's bigoted travel ban. So just today, a Maryland judge and the Fourth Circuit blocked Donald Trump's bigoted travel ban. Do any of you believe we should break up the Fourth Circuit? That would be a no from the witnesses.
I believe in melding it.
Right. The other thing I think we ought to look at is in terms of how these circuits are configured. You do have efficiencies from the way Ninth Circuit is operated. I clerked on there. And it's interesting that my colleagues on the aisle don't want to have those efficiencies. But because of the way it's structured, I don't see any reason why we should change the Ninth Circuit. I think doing so would be purely for ideological reasons. But keep in mind, federal judges get paid to follow the Constitution regardless of where they sit, whether they sit in Maryland or in California or in Washington. And those federal judges have struck down or actually put a block on Donald Trump's travel ban. So it's not ideological. It's judges across the nation that have made this decision. So I think it's strange to say, let's break up the Ninth Circuit, as the president said last night, because a judge in Ninth Circuit said that his executive order was based on bigotry and unconstitutional. Because today, the Maryland judge said the same thing. And I'm waiting for the president to also say, let's break up the Fourth Circuit. But even if you broke up all these circuits, if you had 50 circuits, you'd still have the same number of federal appellate judges sitting there being paid to follow the Constitution. You'd still get the same decisions. It'd just be out of the 29th Circuit instead of the 9th Circuit. You wouldn't get any change in the law that's coming out. So I think this entire hearing is sort of bizarre and useless. And with that, I happily yield back.
I thank the gentleman. We now go to the gentleman from Florida, Mr. DeSantis.
Thank you, Mr. Chairman, and thanks to the members of the court and the professors. Judge Kaczynski, do courts, your court, district court, Supreme Court, just have a roving authority to review actions of the political branches?
No.
So it needs to require a concrete legal case or controversy, correct?
Absolutely.
So if the president does things, Congress does things, it may end up in front of the court properly, but there may just be no way people can get into court for you guys to adjudicate if no one has standing to bring a legal case, right?
Absolutely.
Do you believe that Article III courts possess the institutional competence to second-guess national security decisions made by the president or the Congress?
In general, not.
And why?
I would have to be presented with an actual legal issue to understand. I mean, there are certainly possibilities that the Congress passes a law that gives us authority to adjudicate such an issue. But in general, courts are very poorly informed in terms of making foreign policy decisions. We don't have the information.
Is it safe to say that there would be a difference between a court passing judgment in a proper case between whether action was lawful or constitutional versus whether it was politically wise or the correct policy, correct?
I agree with you entirely.
What are the checks on the courts as you understand the Constitution? I mean, Congress can pass a statute, maybe its president signs it, it goes beyond Congress's authority, you guys, or infringes the Bill of Rights, you guys can have a case before you can effectively check the Congress through a concrete case. You guys get it wrong.
All right, folks, welcome. Thank you very much for choosing us as your stream of choice. President Trump and Speaker Ryan are speaking at the Friends of Ireland luncheon. So we're going to go to that for just a few minutes until President Trump is done speaking. After that, we'll come back to this if we still have enough time. But the Sean Spicer presser is coming up soon. So everything is going to be in one tight spot. So let's go to Speaker Ryan speaking at the Friends of Ireland luncheon. And then after that is President Trump. Thank you.
To introduce a great leader and a great friend of the Irish people, the President of the United States.
Thank you, Mr. President. Thank you. Thank you very much.
Thank you very much, Speaker Ryan, for that wonderful toast, although I've heard better jokes. And thank you to all of our friends and distinguished members of Congress for joining us here today. Great honor, and a really great honor to be with you, Vice President Pence. You have been terrific. And all of our friends welcoming Taoiseach. That's my new friend. This is my new friend. This is a great guy. And Fiola, you know, you are something very special. We sat, we talked, and I think we're friends now too, right? And it's really an honor. Thank you. Thank you. Thanks, Vanilla. Appreciate it. Also, the delegation members, very, very special. We've spent some time together, and we're going to have a very, very great long-term relationship, as we would with Ireland anyway, but this is a very special group, so I very much appreciate it. We're here today to celebrate America's commitment to Ireland and the tremendous contributions, and I know it well, the Irish immigrants and their descendants have made right here in the United States and throughout the world. The very first St. Patrick's Day parade, I spent a lot of time at St. Patrick's Day parades over the years, I will tell you that, was held in my hometown, New York City, on March 17th, 1762. With each subsequent year, the Irish people marched past another accomplishment and celebrated another very hard-earned success, and they have had tremendous success all over the world, but in this country, they have had tremendous success. Over the years, they marched past the beautiful St. Patrick's Cathedral, now an immortal monument to the faith of Irish Catholics in America. They celebrated their shared success in American society with the election of John F. Kennedy. They fought for America in war and combat, and their battlefield courage has earned admiration and acclaim throughout the world. They have great courage. The proud tradition that started in 1762 has flourished and is now celebrated by Americans of all faiths and backgrounds all across our very beautiful and very special land. As we stand together with our Irish friends, I'm reminded of that proverb, and this is a good one. This is one I like. I've heard it for many, many years, and I love it. Always remember to forget the friends that proved untrue, but never forget to remember those that have stuck by you. We know that, politically speaking. A lot of us know that. We know it well. It's a great phrase. The people of Ireland and the people of the United States have stuck together through good times and bad times. Over many centuries, we have built a bond that thrives, inspires, and endures. And with us, it's going to be closer than ever before, I can tell you that. So as we celebrate our shared history and our enduring friendship, let us commit ourselves to working together, as we will, to build on that bond to the benefit of our citizens for many more generations to come. Thank you, God bless you, and may God always bless our deep and lasting friendship and relationship. We love Ireland, and we love the people of Ireland. Thank you very much for being here.
number that was in the testimony, you come up with a 1.84 for every 1,000 cases. And if you look at the last 5 years, it's 1.55 per 1,000, which is a little bit more, but not much more than the 6th district. So I think these statistics really are not very enlightening. And for me, as chair of the California Democratic delegation, it's important to me that the state of California not be divided. Unless the state itself were to divide into 2 states, which is really not something the people of California want or the Congress wants, it's very important that there be a cohesive rule of law in the state of California on these diversity case decisions I think Justice Bayer Kaczynski mentioned earlier. I just want to say there's some other reasons for, you could theoretically take Montana and Idaho out, but it wouldn't materially make a difference in terms of it's just too small a state. And as I think Judge Kaczynski said, there is value in the diversity.
It would make a great deal of difference if I lost my Montana.
It might make a personal difference, but in terms of the number of cases, it wouldn't materially affect it. And why make a change for such a little impact? I just wanted to say, I think it's unfortunate in a way, and I don't blame the chairman. I'm sure this was planned long before the decisions yesterday in Maryland and Hawaii. One of the things that's important for us to do, all of us as Americans, is to defend our structure of government. And that's, the judiciary, the executive, and the legislative branch. And there's a lot of criticism. The president just said recently that, I think just today, that the judge who decided, I don't know whether it was the Hawaii or Maryland judge he was criticizing, had done so for political reasons. I think that's unfortunate. We've all had cases where we disagreed. I certainly have, with circuit, trial court, and Supreme Court decisions. But disagreeing with the outcome is very different than undercutting the rationale for the decision making. And I think it's important that we not do that. Yes, the president is given the power to do a variety of actions by the Congress. He's not given the power to violate the Constitution. And there's certainly, there will be a lot of litigation. We'll see in the end, what the decision is. But I, for one, am confident that the judges who will be hearing this case will hear it with an open mind, with an eye on the facts and the precedents, and come to the best decision that they can. And I don't see how busting up the Ninth Circuit or threatening to do so, sort of in retaliation for a judge in Hawaii. And I'm not saying that that is what is intended, but it might look like that. And I think that that is the last thing that the Congress ought to be perceived as doing, because we ought to have respect for the judicial branch. I do, and I'm sure all the members here do. So with that, Mr. Chairman, I would yield back the balance of my time with thanks once again to especially the justices for coming and honoring our branch of government with their testimony.
Thank you. I'm going to ask unanimous consent that the gentleman from Arizona, Mr. Biggs, be allowed to speak, even though he's not a member of the committee. Without objection, it will be ordered. Additionally, I ask unanimous consent that Senator Flake's written statement be placed in the record at this time. Without objection, so ordered. So the gentleman from Arizona will follow the gentleman from Arizona's written statement. The gentleman is recognized.
Thank you, Mr. Chairman, but I do believe I am a member of this committee. So at least I was so informed. To be informed this way that I'm not a member of the committee is actually quite shocking. But
I apologize, not a member of the subcommittee.
I am a member of this subcommittee. Anyway,
I apologize. I apologize. That is a staff telling, and I'm not blaming
It's
staff,
okay.
but they did
It's good
tell
to be.
me.
It's good to be where you feel wanted. I mean, I could tell you that.
You know, I ask unanimous consent that as a important member of this committee and subcommittee, that you be allowed to speak for the full 5 minutes if we'll reset the clock.
It's the problem of large numbers.
Yes, that's it. Yeah.
You'll notice that the size of the dais is about the size of the Ninth Circuit.
Thank you, Mr. Chairman. I do appreciate it, and thank all the panelists for being here today. And when you are the last guy, as I typically am in these types of committees, even when I am on the committee, there's just so much to talk about that has piqued my interest. This really is the largest circuit. One of the judges mentioned the new 12th Circuit would go on from the Arctic Circle to the Sonoran Desert, unlike the current 9th Circuit, which runs from the Arctic Circle to the equator. This is part of the problem. This circuit represents over 60 million people, which is at least double the size of any other circuit and 4 times the size of the 1st and 10th circuits. And not counting the 9th, the average federal geographical circuit has a population of 22 million. The 9th Circuit accounts for more than 1/3 of all pending appeals in the country, totaling about 13,000 as of the end of last year. At the same time, no other circuit had more than 5,300 cases pending. And last year, it took the 9th more than 15 months on average to resolve a case, more than twice as long as the average circuit, and more than 2 months longer than the next slowest circuit. When Justice Anthony M. Kennedy sat on the 9th Circuit, he wrote to the Commission on Structural Alternatives in support of a circuit split. Justice Kennedy noted that any circuit that claimed the right to bind, and I'm quoting here, to bind nearly 1/5 of the people of the United States by decisions of its 3-judge panel must meet a heavy burden of persuasion. And he later said on a different occasion that I do not think it's appropriate for the judges of the 9th Circuit to lobby terribly hard against it, meaning a proposed split. By the 1980s, the United States 5th Circuit Court of Appeals was in a similar situation, albeit not as grave as it is today in the 9th Circuit. It had 26 authorized judges and an overburdened caseload. In fact, today, the 9th Circuit has nearly 94% of the total population of the 5th and 11th Circuits combined. But at the time, there were similar heightened arguments like we've heard today, about the many detrimental effects of splitting the 5th. But Congress succeeded in splitting it in 1980 through the 5th Circuit Court of Appeals Reauthorization Act. And the question that comes to my mind is, who here would today argue that we'd be better off without the split? Now, we've actually heard some enticing proposals today, and in one of the arguments, one of the summaries presented to us today that are referred to now, the reference was made that there are advantages to a large circuit, and for instance, uniformity of tax laws is best achieved by a large circuit. And then in some issues, the reference was made that maybe a smaller circuit's better. So in this constant position today that maybe a larger circuit may be better leads me to ask this: should we even have circuits anymore? Should we have a delineation by circuits? And if so, should you have some kind of fluctuating number of judges ascertaining or coming on depending on what the issue is of the case before you? So if it's a tax case, should you have 50 judges deciding? If it's some local zoning regulation, should you have 2 judges? The point is, I think that to make the argument that you should adjudicate or potentially adjudicate based on the issue, which is what is suggested by this position, doesn't make a lot of sense. There's no predictability either. Another statement was made about people on the ground, that we should listen to people on the ground. And that was a reference to the judges of the 9th Circuit. But I live in the 9th Circuit. I've litigated and I've litigated as a litigant and as an appellant. I've had cases go. I've talked to many litigators, and it is similar to what Professor Eastman was describing. We had no idea where we were going to go. As a client, my attorneys, very experienced attorneys, I won't mention their names, but they might have appeared before you, would tell me, we have no idea because we cannot decide, because the panel that we will get could be anybody. We will have to wait clearly on who the panel is. By then it's too late. By then it's too late. It actually prevents predictability. It prevents actually due process. And that is the position that I am in, having led the Arizona Senate for a number of years, having been in the legislature where we've had cases go to the Ninth Circuit. We had to try to make decisions because it was taxpayers' dollars we were spending, and it was virtually impossible to predict. And that's the problem with a circuit the size of the Ninth Circuit. I just, when I realize I'm out of time, but there's just so much to talk about with regard to this and to deal with each one of the issues that you raised. But I just can get that back down to this. Justice Sandra Day O'Connor also supported a split of the Ninth Circuit. These are thoughtful people who understand that when you live outside of California and you're dragged in over and over to that district, you are at an incredible disadvantage in getting due process for your client. So thank you. Thanks, Mr. Chairman.
I thank the gentleman. And Andy, again, I'm sorry I stated that.
It's all right.
I'm going to do some quick wrap-ups. Perhaps the minority would want a couple. And I'll try to stay outside of my admonishment of others. Judge, excuse me, Judge Thomas, you had said that combining circuits would be a problem. But isn't it true that to the extent that there is different case law in different circuits, that actually works to the detriment of the greater good of our country, one law? So if, in fact, you were to combine, for example, the First and the Second Circuits and essentially wipe away their case law, make it as though you were in a Third Circuit, so that the precedents would then be essentially open to be considered again by the larger group, would it really be any different than the equivalent of asking the Supreme Court to hear all those ambiguities and resolve them?
Well, yes, in this sense. If you are combining, if you split a circuit, the circuit law applies to the new circuit.
Sure. Now, I understand the split being easy. I don't know that we've ever combined before, but the rhetorical question here really is, at 6 judges, would you admonish that the First Circuit is too small to be efficient and organized and meet the same set of high standards the Ninth Circuit reaches?
Well, my answer is that the litigants and litigators in those circuits depend on the long history of circuit law. And to the extent that there are inconsistencies in that law, that creates some unpredictability in the uniformity of law, and it would be undesirable in my view. What I do think is helpful is our national initiatives to national cost containment and shared administrative services to the extent we have, even across circuit.
I would certainly agree that we can have a separate hearing on the ability to encourage the court to use its funds more efficiently through those practices. Back to the White Commission, and I'm going to hit it tangentially, and this is a somewhat political question, so I think I'll go to my friend Judge Kaminsky. To the extent that political appointments do matter, and you use the Jimmy Carter appointments with some accuracy, then isn't in fact one of the problems, not on your side of the dais, but on my side, the use of blue slips by senators to essentially have a veto over members that they do not like ideologically, regardless of which president is choosing them? Doesn't that essentially exacerbate the partisan nature of your bench?
Well, I hesitate to speak on a matter that's within the purview of another branch. But the matter is quite complicated because, of course, these kinds of decisions are made by the executive branch, by the president is selecting nominees, and then there's pushback from.
Well, let me ask it another way then, perhaps to any of you. If in fact these bodies, the House and the Senate, were unable to resolve the question of blue slips, then if we were to do as the gentleman who has departed would indicate, and essentially make California an island unto itself, wouldn't we essentially create a situation in which the two Democratic senators in California would ensure that only judges, based on blue slip, only judges to their liking would ever get to your seat?
I think by definition what you are asking must be true. If the only senators that the circuit involves just a single state, then the blue slipping power of those two senators would be essentially unlimited.
And Professor Fitzpatrick, I'm going to ask you this because as I look at the for and against, and with some bias for being a Californian, I look at the situation of a single state. I'm sensitive to splitting a state, but I'm looking at a single state solution and saying that essentially under current Senate rules would indicate that you would have very little diversity for as long as the senators had no diversity. And at least in the case of my state, I'm with some trepidation willing to predict that there will be no diversity for a very long time. So how would you deal with that, which is a reality of the political structure, if we were to take what the gentleman, Mr. Flake and Mr. Biggs, had suggested and effectively split off everything but California?
I think it's a big problem, and I think it's even a problem if you're going to throw Hawaii in with California. Still, the two senators in California would have almost complete control over the circuit's judges. That's why I really commend solutions that break California into pieces in some way or another. And you cited the White Commission proposal earlier, and I think there are other ways to do it. But I think that over the long run, that's the only thing that's going to satisfy people.
Right, and Judge Thomas, I'll put you on the spot a little bit because, like all three of you, you were political appointees. You went through a process. The senators did matter. If we cannot change the structure of senators essentially in their home state having effectively a veto, and I'm trying not to be partisan in any way, shape, or form, because if you go to Arizona, you end up with the exact opposite. But if that is a reality, isn't that something that this committee should guard against any circuit which would be essentially politically tilted, if we can do it?
Well, I would hope the committee would make its decision based on not ideological factors, and I take it with confidence in the chairman's prior remarks that that's not the intent. And frankly, I just don't want to opine on what Congress should do internally. I have to leave that to you.
I was asking actually for your observation of the effect if there was a single state solution with, let's hypothetically say, if Arizona were a circuit and California were a circuit, would you, by definition, two states, two very different pairs of senators, current way that the process works, and some of you have gone through the process once, some twice, do you think that you would end up with vastly different circuits, and they would be one-state circuits? And is that something we should generally guard against?
Well, if I might answer more generally, I think one-state circuits are a bad idea for a whole variety of reasons, some of which you've just identified.
Okay. Any other questions? Okay. I'd ask, would you all be willing to take some follow-up questions? A number of members were not able to get here. They had competing markups.
Of course.
Okay. Well, then we'll leave the record open for 5 days. For 5 days, plus whatever time it takes for you to respond. And with that, this concludes today's hearings. Again, I want to thank all of you. The weather is clear. You're be unrestricted. With that.
All right, folks, thank you very much for joining us. This is going to continue. This was just the first part of the proposal to split the court, the leftist court, from the state of, from I think it's Washington all the way California. It also includes Arizona and some other states. But yeah, this court completely needs to be dismantled. It needs to be split. These judges run wild with leftist ideology, and their bias is extreme. So by disbanding it, by splitting it up, hopefully they can get some more judges in there that will balance the scale. And we just hope that they do actually split it. It's causing more problems than it's solving. It takes an extremely long time for them to get through all of the cases that they have to come by. Sometimes the cases can go on for years before they even seen in court. So it's very disgusting. Now, there is a Sean Spicer presser. The stream will start soon. The link is in the description below. I'll also put it up on the chat. So make sure to go and check it out. Set the notification if it's not live yet. And I hope to see you guys in the chat. It's scheduled to start at 11 a.m. Pacific, 1 p.m. Eastern. We'll start the stream around 10:15. We'll put on some music, do all that good stuff, get the people into the room. And once it starts, we'll go there live. Thank you very much. It's funny how people they think that these idiots that you guys see talking on the streams or in the Senate or whatever represent California. They absolutely don't. There's so many different types of conservatives, left-leaning moderates, and right-leaning moderates and right-leaning independents here in California. Just as an example, Breitbart, Drudge, myself, Golden State Times, we're all in California. We're like 10 minutes away from each other. So we're like a nerve center in the middle of the bluest part of California, trying our best to get to turn this state around. Again, Breitbart, Drudge, and myself, Golden State Times, working very hard to turn this state red. So don't give up on it yet. It's coming, and it's coming soon. We are based in the city of Santa Monica, California, the bluest part of, well, one of the bluest parts of California, right? LA County. But yeah, we are centered in the ocean city of Santa Monica, California.